video, we're going to be talking about the different roles of the lawyer. This section of the rules makes up 4 to 10% of your total MPRE examination. The first rule that I would like to direct your attention to is lawyer as an advisor. The rule says that in representing a client, a lawyer shall exercise independent, professional judgment and render candid advice, even if it's not what the client wants to hear. In rendering advice, a lawyer may refer not only to law, but other considerations such as moral, economic, social, or any political factors that may be relevant to the client's situation. So turning to your example found in your outline on this point, it says that a client comes to a lawyer because he wants the lawyer's opinion regarding a business transaction. The lawyer thinks, based upon his expertise in the field, that it's a bad idea to enter into this transaction. The lawyer must tell the client what he believes. So to stop here, the idea behind this rule is that sometimes lawyers are relied upon to provide an opinion. And it might not just be an opinion based upon the law, but instead it could be because the lawyer knows the client's business. The lawyer knows the client's goals, and the lawyer knows and understands applicable social and political ramifications of an action. So when it comes to a lawyer acting as an advisor, it's a lawyer's obligation to give clients candid advice, even if it's the type of thing the client might not want to hear. Turning to our role as an evaluator. The rules state that a lawyer may provide an evaluation of a matter affecting a client for the use of someone other than a client if the lawyer reasonably believes that the making of the evaluation is compatible with other aspects of the lawyer's relationship with the client. So what does this mean? Well, turning to the example in the outline, it says such an evaluation may be for the primary purpose of establishing information for the benefit of a third party. An opinion concerning the title of property rendered at the request of a vendor for the information of a prospective buyer. So let's expand on this. Let's say a lawyer has a client with a pretty large investment portfolio that contains a lot of real property. The client is looking to sell some of its land. The lawyer knows that to help facilitate a sale, the lawyer needs to get the land evaluated. An evaluation could help determine or ensure title or value. This evaluation may get handed over to third parties so long as it is favorable. There should not be an issue with the lawyer utilizing it to help facilitate a sale. The next part of the rule tells us that when a lawyer knows or reasonably should know that the evaluation is likely to affect the client's interests materially and adversely, the lawyer shall not provide the evaluation unless the client gives informed consent. Further, the rule notes that except as disclosure is authorized in connection with a report of an evaluation, information relating to an evaluation is otherwise protected by the confidentiality rules. Remember how we defined our duty of confidentiality. It pertains to information that we learned about our client throughout the representation of them. Anything that falls into that category is protected by our duty of confidentiality. Thus, if you have an evaluation done, let's say of your client's real estate, that by all means will be protected or covered by our duty of confidentiality. And I think this makes sense because it's information that you're learning throughout the representation of your client that pertains to that representation. For example, let's say you have a piece of property evaluated for your client, and unfortunately, it comes back that there's toxic waste on the property. This is a huge problem because now your client can't sell it. It's not only worthless, but there's liability related to properly cleaning up the waste. So in such an instance, you would definitely want to give this information to your client and let him or her direct you about how to move forward. And that's because this evaluation is confidential. It falls under the duty of confidentiality, and you cannot share it with anyone without first getting your client's informed consent. The next rule that I would like to discuss is about prosecutors and other government lawyers. First, let's talk about the rationale behind these rules, and then we'll turn to the rules themselves. We find this rationale in the comments to the rules. It tells us that prosecutors have the responsibility of a minister of justice, and not simply that as an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice, that guilt is decided upon the basis of sufficient evidence, and that special precautions are taken to prevent and to rectify the conviction of innocent persons. This means there are additional ethical burdens placed upon prosecutors and other governmental lawyers. So, the way I like to think of this to help frame these rules is as follows. I like to think of regular lawyers or non governmental lawyers as being on a lower rung of a ladder. We, of course, have ethical responsibilities, but we do not have the same job as a prosecutor or government lawyer. So, we do not have the exact same ethical obligations. Above us, regular lawyers on the ladder are those governmental lawyers or those prosecutors. And yet above them are judges. And this is because judges have an even greater ethical obligation than the rest of us lawyers. We'll talk about judges in another section. So hopefully that helps frame the rules. The first rule that I want to talk about says, the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. If you've studied the Fourth Amendment or you've taken a criminal procedure class, you know that probable cause is the backbone of our criminal justice procedures. And here, this ethical requirement on prosecutors is reflecting back on that basic point. They need probable cause before they prosecute a charge. Prosecutors should not be violating anyone's rights, let alone a criminal defendant's. So, if there's not probable cause to move forward with the charge, they simply shouldn't be moving forward with it. I want to give you one quick example so that you can make sure you're reading these fact patterns carefully. Let's say a lawyer is a prosecutor in a case where a defendant's been charged with murder. And the prosecutor knows there's probable cause to move forward with prosecution, but the prosecutor doesn't believe that the jury is actually going to find that the defendant committed murder beyond a reasonable doubt. And the prosecutor decides to move forward with the charge anyways. Has the prosecutor done anything wrong? Has the prosecutor violated any ethical rule? And the answer is no. As long as that prosecutor has probable cause to move forward with that prosecution or the charge, that's all that's required. Even if they don't think they have enough evidence to convince the jury that this person committed the crime beyond a reasonable doubt, that's okay. That is not what this rule requires. The rule simply requires probable cause to move forward with the charge. Getting back to the rule, it says that prosecutors in a criminal case shall make reasonable efforts to make sure that the accused have been advised of their right to obtain counsel, the procedure for obtaining counsel, and has been given a reasonable opportunity to get counsel. Because again, this is their right, and these lawyers here, as governmental lawyers or prosecutors, should not be violating anyone's rights. Moving on, the rules state that a prosecutor should not seek to obtain from an unrepresented person a waiver of important pretrial rights, such as the right to a preliminary hearing. So if you have a criminal defendant that doesn't have a lawyer yet or is otherwise unrepresented, you as a prosecutor should not seek to use this as an advantage. Don't get them to waive important rights. The next rule many people know is the BRADY rule, and they know this if they've taken a criminal prosecution class. But it's also an ethical responsibility upon prosecutors. The rule says, prosecutors in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or to mitigate the offense, and in connection with sentencing, disclose to the defendant and to the tribunal all unprivileged mitigating information known to the prosecutor, except where the prosecutor is relieved of this responsibility by a protective order of the court. So the idea here is, remember, prosecutors shouldn't be violating anyone's rights. So if a prosecutor comes across evidence that helps the defendant, they should be handing it over to the defendant. They shouldn't be keeping it or hiding it from them. Turning to the example in the outline, it says if a prosecutor discovers a witness that says the defendant was acting in self-defense when he shot the victim, the prosecutor must disclose this witness to the defense. Again, this is helpful evidence to the defendant or mitigating evidence to the defendant. So the prosecutor has the ethical responsibility to hand it over. The next rule I want to talk about still relates to prosecutors. This rule makes a great multiple choice question, and in the past, Many people have asked us questions about it, so it's worth going over. It says that when a prosecutor knows of new, credible, and material evidence, creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court or the appropriate authority. Further, if this conviction was obtained in the prosecutor's jurisdiction, they must promptly disclose this evidence to the defendant unless the court has authorized delay for some reason, and undertake further investigation or make reasonable efforts to cause an investigation in order to determine whether the defendant was convicted of an offense that they did not commit. So let's stop there. If you're a prosecutor in New York, and while you're investigating a case, you come across new credible evidence that creates this reasonable likelihood that someone is sitting in jail in Florida for a crime they didn't commit, what do? Well, the first part of this rule says that you have to hand that evidence over to the appropriate court or the appropriate authority. So, in accordance with this rule, you would give that information or evidence to whatever jurisdiction is applicable in Florida. But the rule doesn't stop there. Let's change our facts to illustrate the point. Let's say that you're a prosecutor in New York, and while you're investigating a case, you come across evidence that creates this reasonable likelihood that a convicted defendant in your jurisdiction did not commit the offense in question. Well, in that instance, since it's your jurisdiction, you have an even greater burden to act as a prosecutor. Now you need to give that evidence to the defendant, assuming the court hasn't told you to stop or delay for some reason. And again, you're not done. Pursuant to the rule, you now have to take steps to undertake an investigation to get to the bottom of whether or not this person is sitting in prison for a crime they didn't commit, or make sure someone else is investigating to get to the bottom of that issue as well. Still on that point, but slightly different, the rules tell us that when a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that they didn't commit, the prosecutor shall seek to remedy their conviction. So what I want to stress about this rule is the language of it. The rule says that the prosecutor has clear and convincing evidence. For example, Anna is a prosecutor, and she gets a confession from someone who turns themselves in, saying they committed a crime in her jurisdiction. And there's matching DNA evidence to support that confession. But someone else has already been convicted of that crime, and they're in prison for it. So Anna needs to take action to remedy this conviction. This is because Anna knows of clear and convincing evidence that shows a defendant in her jurisdiction is serving time for a crime they did not commit. Therefore, the rules are similar, but there are different standards. So you can see how this makes a great question. So we're still talking about the different roles of the lawyer, but we're going to switch gears just a little bit. I want to talk about a lawyer representing an entity or an organization. These rules tend to present challenges for some because corporations or organizations are not people. And when you represent a person, let's say a person named Bob, you know who your client is, Bob. But when it comes to an organization, it can be more difficult to discern who exactly your client is. So let's talk about our duties representing an entity or an organization. First things first, the rules tell us that our duty of loyalty runs to the organization itself, not the people who run it or its constituents. So to be clear, if you're representing a corporation and there are shareholders and officers and directors within that corporation, your duty runs to the corporation itself, not necessarily the people who run it. Further, the rule states that in dealing with these organizations' people, like directors or officers or employees or members or shareholders or any other constituent, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. So if a lawyer is representing a corporation and they come to find out that one of the directors of this corporation has an adverse interest to the client, the corporation, the lawyer needs to make sure that they clarify their position and they clarify who the client is to this director in question. Maybe the director forgot, and they do need to be reminded that the corporation's lawyer is not their lawyer. And thus, the lawyer does not have their best interests in mind, but instead has the corporation's best interests in mind. Turning to the first example found in your outline, it says, a business manager admitted to general counsel that he used threats of violence and defamation in order to help maximize the profits of the organization. The general counsel should remind the business manager that he represents the corporation and not the manager, and that threatening people is illegal, and that the business manager might need independent representation. Next, I want to discuss a lawyer's obligation to report when they come to find out that there is some sort of violation of law or regulation, and who they're supposed to report to. The rule tells us that if the lawyer for an organization knows that a person associated with that organization is acting or going to act in a manner that is a violation of a legal obligation to the organization, or is in violation of law that reasonably might be imputed upon that organization, and is likely to result in a substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interests of the organization. So I'm just going to stop there for a second. Let's say you're representing a corporation, and you come to find out that an officer or a director is doing something that amounts to a violation of the law, and as a result, it's likely to be imputed onto your client, the corporation. Well, you have an obligation to act. The rule here uses very strong language. It says you shall proceed as reasonably necessary in the best interests of your client. In other words, it's commanding you to act. But the rule doesn't stop there. It gets more specific. It tells us, unless the lawyer reasonably believes that it's not in the best interest of the organization to do so, the lawyer shall refer the matter to the higher authority in the organization, usually the board of directors, including, and if warranted by the circumstances, the highest authority that can act on behalf of this organization as determined by the applicable law. For example, this is usually an outside board of directors. Thus, the rule says that unless you believe you don't have to, in other words, unless you think it's not in the best interests of your client, this corporation or organization, you shall, meaning must, report up to the highest authority that can take action on behalf of your client. So if you find out an officer is violating a law that's likely to cause a substantial injury upon your client, you shall report up to that highest authority, maybe the board of directors or that outside board of directors that can act on behalf of your client. Further, the rule states that if despite your efforts, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action, or if they refuse to act that is clearly a violation of law, and the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal information relating to the representation, whether or not the rules of confidentiality permit such a disclosure, but only to the extent the lawyer reasonably believes is necessary to prevent this substantial injury to the organization. So this means if you find out that something is happening and it's going to result in a substantial injury to your client, the organization, and you report up, let's say to the board of directors. And let's say the board of directors refuses to act, or they don't take correct action. This rule says that if you reasonably believe that this substantial injury is going to occur to your client as a result of this failure to act, then you have the ability to report out. And you're even allowed to disclose confidential information as is necessary to prevent this substantial injury that might occur to your client or this organization in question. However, the rule is careful to say that you should limit whatever you're disclosing to whatever is reasonably necessary to effectuate your goal. In other words, you're not going to reveal all information, just whatever as is necessary to prevent this substantial injury to your client. The other thing I want to point out is that this rule uses the word may. So you don't have to report out. Remember, you must report up or you have to report up, but you don't have to report out. The rule utilizes the word may for reporting out. The next thing I want to touch upon is the exception. I see many questions on this exception, so it's worth noting. It says that this shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law or to defend the organization or an officer or an employee or another constituent associated with the organization against a claim arising out of the alleged violation of law. So, to give you an example, let's say Sarah represents a software corporation, and there are some allegations that one of the officers has engaged in some sort of action that amounts to a patent infringement. The corporation has asked Sarah, as their lawyer, to investigate these allegations to see whether or not the officer has, in fact, committed a violation. So, if Sarah investigates and finds out, yes, the officer unfortunately has broken the law, and she decides to go and hand this information over to the prosecutor. Is Sarah in trouble for doing so? And the answer is yes, because Sarah has been hired to help get to the bottom of those allegations, not to go and tell on the organization. Instead, they wanted Sarah to report back to them about her findings so that they could take action and try to remedy the situation. But instead, Sarah reported out. Sarah just went and told on her client, and she is not allowed to do that. The final rule that I want to cover is the Sarbanes-Oxley Act. This act was passed by Congress in 2002, and it instructs our Securities and Exchange Commission, the SEC, to make rules for security lawyers who discover clients violating federal or state securities laws. Thus, this rule applies to security lawyers. And to clarify what this means, these are lawyers who represent the issuer of a security and who practice before the SEC. This includes lawyers who transact business with the SEC or communicate with the SEC or give advice on documents that get filed with the SEC. Pursuant to this act, the rules state that security lawyers who become aware of credible evidence that their client is materially violating a federal or a state securities law must report it to their client's chief legal officer, CLO, or their chief executive officer, the CEO. This applies if there is credible evidence that a client's personnel has breached a fiduciary duty under a state law or federal law, or committed a similar material violation under federal or state law. So to stop here, if a lawyer finds out about credible evidence that their client is violating a federal or state securities law, there's this mandatory reporting requirement. The rule uses the word must. And it gets more specific than that. It tells us who we have to report to, specifically the CLO or the CEO. But again, it doesn't stop there. It then goes on to explain that the person the lawyer reports to, the CLO or the CEO, must then determine whether or not a violation has in fact occurred. In other words, it's putting an ethical responsibility and a legal burden upon them to investigate. If a violation has occurred, then an appropriate response to it is required. The CLO must take all reasonable steps to have the client make an appropriate response. For instance, to remedy the situation and to make sure it doesn't happen again. The CLO has to report these results to the securities lawyer. Now, if an appropriate response is not taken, then there's an additional requirement on the lawyer. The securities lawyer must report this evidence to the client's board of directors, to an audit committee, or to a committee made up of outside directors. Again, this is a mandatory reporting act. So if once the lawyer has reported to the CLO and the CLO decides to do nothing, the lawyer cannot say, oh, well, I did my job. The lawyer has to report to one of those three entities. Finally, the securities lawyer may reveal this information to the SEC, and they can do this without the client's consent. Any confidential information can be shared that's reasonably necessary to stop the client from committing a violation that will cause substantial financial injury to the client or an investor, to rectify the injury if the lawyer's services were used to facilitate that violation, or prevent the client from committing perjury in an SEC matter or any matter within the jurisdiction of any branch of federal government. So this last part of the rule says that you may report out to the SEC and give up confidential information, even without your client's permission, if one of these three instances are applicable. So that wraps up our discussion of the different roles of the lawyer.